Hi, my name is Cannon Moore. I'm a bankruptcy attorney and the owner of Cannon Moore Law in Central Texas, where we help Texans get out of debt by filing for bankruptcy. So today, I'm going to be answering the question, what is a Chapter 7 bankruptcy? Now, that's a really broad question, and I'm not going to be able to tell you every aspect about a Chapter 7 bankruptcy. So what I'm going to do instead is I'm going to kind of give you the nuts and bolts version. I'm going to give you 5 of the bigger kind of fundamental key points about a Chapter 7 bankruptcy. And then I'm going to give you 4 of the smaller, kind of finer points that are also really important for you to understand from the outset. The first thing that a Chapter 7 bankruptcy is a process to eliminate debt. Now, I'm sure you already know that, and that's why you're considering a Chapter 7 in the first place. But it's worth pointing out that a Chapter 7 bankruptcy doesn't eliminate all types of debt. It's specifically designed to get rid of certain unsecured debts. If you want to know more about that, check out the video linked below about what kind of debt you can get rid of in a Chapter 7 bankruptcy. Before I move on to point 2, I want to point out that unlike other types of bankruptcy, there's not a limit on how much debt is too much debt to file a Chapter 7 bankruptcy. Similarly, there's not a minimum amount that you have to have either. This is really a moving target that depends on you and your circumstances. For some people, that can be $10,000 or $8,000 or maybe even $20,000 or $75,000. It just depends on you and what your situation looks like. What I would say though is that if you're considering a bankruptcy and you're not sure if you have enough debt to make filing worth it, you're at the point where you should consider talking to a bankruptcy lawyer. The second big point about a Chapter 7 bankruptcy is that it's a legal process that takes place in specialized courts set up just for bankruptcy. But that doesn't necessarily mean that you and your attorney are going to go and argue your case before a judge. That certainly happens sometimes, usually because there's some sort of dispute or disagreement between the creditor and the debtor, but it's absolutely not the standard practice in every case. Now, although you may never sit at counsel's table in the court and watch your lawyer argue your case in front of a judge, you're definitely going to meet the trustee at a 341 meeting. The trustee is the third big point about a Chapter 7 bankruptcy. It's important for you to know from the very beginning that there's going to be a Chapter 7 trustee assigned to your case. You're going to meet them at the 341 meeting, and their job is to protect the creditors and make sure that the process is fair for them. And one of the ways that they do that is by finding and liquidating any non-exempt assets that you might have. And they're going to do that by reviewing everything that you file. And then when you and your lawyer and the trustee are all together at the 341 meeting, the trustee is going to ask you questions to verify that everything you filed with the court is accurate. And if anything that you filed piques their curiosity, they'll ask some questions on that too to dig a bit deeper and see if there's anything to uncover. This brings us to the fourth point of a Chapter 7 bankruptcy, which is the concept of a no asset case. So every Chapter 7 bankruptcy is either going to be an asset case where non-exempt assets exist for the trustee to sell and give the money to the creditors, or the case is going to be a no asset case, which is a significant number of the Chapter 7 bankruptcies that are filed. And the reason why so many cases end up being no asset cases isn't because the majority of people filing for Chapter 7 literally have nothing. It's because the people in these no asset cases are able to protect what property they do have using exemptions. So it's really important to understand what exemptions are available to you, how to use them, and which ones you should be using. The fifth and final big point that you should know about a Chapter 7 bankruptcy is that you have to qualify in order to file one. Now, the way that we figure out if you qualify for a Chapter 7 is by using the means test. And what the means test does is it factors your income with all of your expenses and the allowable deductions, and it calculates your monthly disposable income. Depending on what that number is, will tell us whether you qualify for a Chapter 7. I know that sounds formulaic, and it is. It definitely involves some math, but the means test is actually pretty useful and can be used to tell your story and to explain maybe why you should qualify for a Chapter 7 bankruptcy, even though you're a higher income earner. So understanding the means test and getting it right can be really crucial for you if you're someone who maybe should file for a Chapter 7 bankruptcy instead of a Chapter 13, but the numbers seem to be saying otherwise. All right, I'm going to run through these finer points kind of quickly, so here we go. Number 1, there's a filing fee that you're going to have to pay in addition to your attorney's fees if you hire a lawyer. Number 2, you have to take 2 credit counseling classes. Number 3, This is really straightforward, but it's extremely important. You have to be truthful and transparent throughout the entire process, and failure to do so can actually result in criminal penalties in certain situations. Number 4, Chapter 7 is usually pretty fast, and you should have your discharge within about 4 to 6 months after you file your bankruptcy in a no asset case. All right, so those are kind of the high points on what a Chapter 7 bankruptcy is. If you're in the Central Texas area and you're looking to consult with a bankruptcy attorney, give my office a call.